Jim, how will Proposition 3, if passed, affect a medical professional's ability to render their professional suggestions to their patients?
Well, let's take another hypothetical example, okay?
Okay.
Let's suppose we have a 15-year-old girl, and she goes to a gynecologist, and she tells the gynecologist, look, I'm not happy with my gender. I identify as a different gender.
Sure.
And I want to be sterilized because of my sexual orientation. Okay?
Okay.
Now, let's suppose this doctor says, hey, I'm sorry, I'm not going to perform this type of a procedure on a 15-year-old girl who is, at least not in my opinion, she doesn't know what she's going to want for sure when she's 30 years old. Because you're so young, I am not going to perform this procedure on you. Okay. Now, can she enforce her constitutional right to sterilization? First, I guess we have to ask, is there a compelling state interest which would allow the state to, which would allow the doctor to deny or burden or infringe on her fundamental right to sterilization? And remember, we read the definition of what a compelling state interest is.
Right. But for the doctor,
Yeah.
in the second sentence of the first section, an individual's right to reproductive freedom shall not be denied, burdened, nor infringed upon. So if this...
Unless there's a compelling state interest.
Unless there's a compelling state interest achieved by the least restrictive means. Well, this is a private practice doctor
Right.
approached by a 15-year-old girl. They say no, well, their no would be an infringement, would it not?
It would be.
Yeah.
And I don't think there's a compelling state interest. It wouldn't be for the health of the person seeking care. And,
Potentially.
And it would violate her autonomous decision.
It would violate, yes, it doesn't meet both
It doesn't meet both
requirements.
tests. I don't know if it even meets one of them. So the doctor has violated her constitutional rights. Well, remember I mentioned before that the Supreme Court has now said that every individual has a cause of action for the violation of their constitutional right. This 15-year-old girl needs to find a lawyer, sue
that doctor.
Sue the doctor. And along this same line, I'm going to kind of digress a little bit.
Okay.
We also have in Michigan something called the Elliott Larson Civil Rights Act. And that act says something like this. It says, except where permitted by law, and that's an important clause, a person shall not deny an individual services or accommodations of a place of public accommodation on the basis of, and it gives a lot of things, religion, so forth, but sex, including sex, okay? Now, there is a case that was decided back in 2011. It's called Moon versus Michigan Reproductive and IVF Center. It's found at 294 Michigan Appeals 582 in case anybody wants to read it. And it says this. It says that under this Elliott Larson Civil Rights Act, this law requires a doctor and this law requires a doctor and medical facilities to provide these services to people and cannot deny those services based upon a protected status. And one of the protected statuses in the case I'm talking about, the Moon case, is marital status. In that case, the person was not married and the doctor refused to provide infertility care. And the court said you can sue them for that. Now here, you're denying it because of the child's age. you're also denying it, I believe, because of sex. Because sterilization is a matter relating to pregnancy, and pregnancy is related to sex. And just recently, again, less than 3 months ago, in the last of July, the Supreme Court extended the definition of sex to include gender identity and sexual orientation. So, this is a little complicated, and sorry for that. Under the Elliott Civil Rights Act, remember it started out saying except where permitted by law. Once this constitutional amendment says she has a fundamental right to sterilization, it's no longer permitted by law. So, if I were representing her, and I decided I wanted to file a lawsuit against the doctor, against her, I would file a lawsuit based both on the violation of her constitutional right, and secondly, based upon the violation of the Elliott Larson Civil Rights Act. So I guess there's another example where I think there is a potentially large effect, a ripple effect from this proposition.
Wow. So when people say this proposition goes way beyond Roe, this goes way beyond Roe. This goes into medical decisions. I mean, this is...
I believe it will. And now, okay, the example I gave you, it was a 15-year-old girl, right?
Sure.
Now, somebody might say, oh, but she's a minor. We should treat minors different than what we treat, say, somebody that's 18 or 20 years old.
But that's not what this amendment to the Constitution
It doesn't say that. And in fact, I think you have that in front of you. Is it Section 2? Why don't you read Section 2?
The state shall not discriminate in the protection or enforcement of this fundamental right.
So,
Oh,
discrimination is treating people who are somewhat similarly situated differently. In this case, if you were to say, if an 18 or 20-year-old is entitled to the protection and enforcement of the right, unless you're going to discriminate based upon age, you've got to provide the same protection to a 15-year-old.
Or a 15-year-old is entitled to the fundamental right of reproductive freedom to make and effectuate all decisions in all matters about pregnancy, including but not limited to, say, a 15-year-old is making a decision based on postpartum care. They're entitled to that right.
Yep.
Well, then why wouldn't a 15-year-old, based on sterilization, be entitled to that right?
And you can't discriminate.
You can't discriminate again. You can't parcel that out. Well, she's giving birth, and this one's trying to sterilize.
Exactly.
You can't do that.
Exactly. And you can't. I don't think you can discriminate based upon age either. That you can treat a 15-year-old different than an 18-year-old because you can't discriminate according to this proposition. So that, I think, is another example of maybe what would be an unexpected consequence from passing this proposal.
I think these are unexpected, a lot of these, that in the language, as you were saying, if they were your client, this is how you would recommend it. And that is how you would plead their case. I think a lot of people aren't thinking that way in the terms of how would a lawyer look at this. And I think this conversation that we're having is really important to help educate people that this goes way beyond Roe. Proposition 3 is a very broad proposition that does change our Constitution, which puts it over any legislative body. So anything that this covers, now the legislature cannot do anything about it. Please read the full language of this constitutional amendment. I've supplied it here on the website. And know what you're voting for this November 8th.